It is universally agreed that the rule of law is a worthy ideal that should be treasured and preserved, at least until it becomes inconvenient. Yet there is not universal agreement as to what this expression, the rule of law, means. It certainly does not signify a legal rule, but more generally rule by law as distinct from rule by power, free of legal constraint. Whether that legal constraint is by a democratically elected body or a tyrant or otherwise. So the ideal of the rule of law signifies that the institutions of the state, and in particular the individuals and bodies that are invested with power by the state, should be subject to the law rather than above it. There are narrow and broad meanings of the rule of law. According to the narrow meaning, the rule of law is not concerned with whether a law is a good law or a bad law, but only with whether the law is applied equally to everyone. According to the broader meaning, however, the rule of law ideal embraces human rights standards. On any reckoning, both the rule of law and human rights standards should be respected, observed and protected. The only question is the semantic one, whether we properly treat the notion of the rule of law as embracing human rights standards. Even if we treat them as distinct, a violation of human rights will often involve a failure to observe the rule of law, and vice versa. In a federal system, the sovereignty of Parliament is qualified by the bifurcation of power between the federal Parliament and the state or provincial parliaments. But within their respective fields, under the Federal Compact, the rule of law is relevant both in the federal sphere and in the state sphere. Apparently it was Professor Dicey who coined this expression, the rule of law. Part 2 of his treatise was headed, The Rule of Law. Chapter 4, which was the first chapter in Part 2, was headed, The Rule of Law, Its Nature and General Applications. Now, if you read Professor Dicey's work today, I think you will agree with me that it does appear very chauvinistic, dated, and sexist. Yet, it's a good starting point, if for no other reason than that generations of lawyers, including my own generation, when I first studied law in the late 1950s, were brought up really with Dicey's rule of law as the starting point.